I think we have everyone in out of the waiting room. So we'll probably just start getting going and let folks filter in as they will. Just to make sure we can give the maximum screen size if you're not presenting, so you're not Leah basically. And Ari, if you wouldn't mind turning off your videos, and then we can unmuting yourselves. And with that, to start it off, so Ari's going to be moderating. I'll go ahead and pass it over to Ari, and we'll get going.
Thanks for joining us here. So with the three of us running this, myself, outfitter, you got Leah Corrigan, attorney, and river guide, Aaron Lieberman, the executive director of IOGA. Really, the key point is hopefully everyone on here has watched the virtual campfire, the first one. If not, you're going to kind of be a little bit out of the loop. There was a video sent of that. Once we go through this, keynote kind of presentation, we'll have an opportunity for questions. Questions will need to be sent via chat. Please send to all of us. All right, you like to send not to individuals, and then we'll be, kind of taking all the questions and finding ones that are most pertinent or repeated, or that are important to people, and answering them one at a time. There's no questions that aren't good, so please bring them. We're still all learning. I think it's a key element here. We're still all learning. We're not. There's a lot. Things are constantly changing, in flux. We're learning every week as we go, and adapting and trying to make strong insights and decisions. So please be patient, and there'll be another virtual campfire to follow. If there's more questions, we'll do our best to keep everyone up to date. But let's just keep this. I think that's it. That's it for me. So thanks for being here.
Thanks, Ari.
From you?
I think Ari mostly covered it. So again, for introductions, we have Ari, Leah Corrigan. I'm guessing most folks here know. Most folks in our industry do. With the Recreation Law Center, she has given us. I'm sure she's been a mainstay at IOGA meetings, presentations for some years now, and around this issue has already presented once earlier this month, trying to help us just wrap our heads around the situation. So we're really lucky to have her. She's going to be presenting for the most part. I'll jump in for certain segments, and then when we open up for Q&A, it'll sort of be between both of us. I think Ari sort of pointed to, or maybe we had the agenda up at some point. I have it over here on a different screen, but we'll go through, we just hit introductions. We'll go through an overview, so where we came from, in brief what we covered last time. Really, we're going to skip by quite a bit of content that we went over in the first virtual campfire. So if you feel out of the loop, if you didn't watch that one, you might just go back and fill in those blanks afterward. And as Ari said, we'll hopefully get to Q&A by the end. A couple of the ground rules. As Ari said, there will be questions. You can put your questions down in the chat, and make sure that you're sending it to everyone, and we'll filter those out as we go. Try to keep statements out of there. So there are a lot of strong opinions on this. That's great. We just want to keep it to constructive, respectful questions. And if you could please just stick away from any personal examples. So whether that's using your own outfit or referencing somebody else's, we want to stay away from any personal examples. And I think I'll leave it to Leah to give the disclaimers and caveats about what this is and what this isn't in terms of from a legal perspective before we jump in. With that, unless I miss anything, Leah, I'd pass it over to you for those disclaimers.
Okay, great. So this is just standard kind of legal disclaimers, but let me first just tag on to something Aaron said. What we're talking about in these presentations is a question of present legal compliance, right? And future legal compliance. So it should go without saying that things like that need to be handled very delicately, and we don't want to put things in the chat that's going to create a question about whether any given person is or isn't in legal compliance. It's very complicated. Everyone's situations are different. This overview is to give everybody a sense of what the rules are, because the landscape has changed even since our last campfire talk, but not to give anyone specific advice. So please don't rely on anything I'm saying here, even if I am your lawyer. Everyone's situation really is unique, and these rules are complicated, and so you shouldn't rely on this, but it should give everyone a pretty good overview of where we presently stand. Okay, so here's where we presently stand. Since the last campfire talk, which was not even a month ago, 2 or 3 weeks ago, the landscape has dramatically changed again. So the information that you've got in the last campfire talk is still useful. It's a good overview for understanding the situation. The point of that talk really was in part to bring guides on board so everybody's on the same page, knows what's going on, lines of communication are open. So that's all still relevant, but the legal landscape has changed since then. And I'm going to walk you through that. It's easier to understand where we go next when the entire process of what has occurred in the past is in context. So we'll go over that very briefly again. I'm going to assume that everybody watched the other presentation, so I'm not going to delve into details, but I just need to give you again, here's where we were, so you understand where we're headed next. Okay, so during the last webinar, where we were was the Biden executive order and the Obama executive order preceding it had the force of law for federally permitted outfitters. So what was in place as of the end of January in 2022 that were really relevant to Outfitters and Guide were those executive orders. Those executive orders had supplemented and materially changed existing law. It's been in place for many, many years, which is the Fair Labor Standards Act. So that is where we were February 7th. What that did, try to increase my screen there. Those executive orders did 4 things. Number 1, increase the minimum wage significantly. In Idaho and under the Fair Labor Standards Act, it was $7.25. Those numbers went way up with the executive order. Number 2, it clarified the application of overtime pay rules. So the Fair Labor Standards Act has been in place for many years. Outfitters and everyone else have been subject to that Fair Labor Standards Act. But the executive order changed in some details the way overtime was analyzed for outfitters. Generally, it required that overtime pay, time and a half, be paid for every hour over 40 hours. And it really removed some exemptions that could have theoretically changed that overtime analysis for certain guided outfits. Number 3, it specifically referenced outfitting services in the executive order. And that's a really critical point. When you as a group are specifically called out in rulemaking or executive order, there is going to be a corresponding enforcement mechanism or basically the federal government paying more attention to you specifically if you're called out. So if meatpacking industry is called out or whomever, tech, then that executive order has made a policy announcement that they intend to enforce the new rules specific to this group. That specifically calling out outfitted services really changed the possible enforcement landscape. So we used to be able to hang out in the Frank Church, everybody do their thing. That is highly unlikely that we get to go back to that place. The fourth thing that happened is it built in future annual wage increases without further federal action. So again, this slide is telling you what those two executive orders did, and that's where we were on February 7th when we had the last campfire talk, okay? Then, or current with that talk happening, there had been some legal challenges to the executive order. One of those that we talked about a little bit in that campfire talk was Duke Bradford and Colorado River Outfitters Association versus the Department of Labor. That lawsuit was filed in the United States District Court for the District of Colorado. They asked for an injunction of the of basically the provisions of the executive order. An injunction means that I go to the court and I say, court, this law is illegal and you should stop it because it's going to so drastically affect my business. You should stop it while you decide whether it was actually illegal. So that lawsuit was filed, and while we had this campfire talk, the Colorado court had said, no, we're not issuing the injunction, and drafted an order that was really kind of brutal, saying that there was no standing and other legal concepts that really made all lawyers who are tracking this think, oh, this is going to be an uphill battle to legally challenge this. There is also presently, the state of Idaho has filed suit against the executive order. IOGA is engaging with attorneys and communicating with the AG's office on that lawsuit. That lawsuit, for the purposes of what we're talking about right now, probably isn't going to change anything because there's already an injunction that was issued by the 10th Circuit, and we're going to talk about that next. Okay, so here is a synopsis of where we are legally. The Bradford lawsuit was filed. The Colorado District Court said, I'm not giving you the injunction. Then we had this campfire talk. I told you, I think, in pretty certain terms, that I didn't think there was much chance of that appeal being successful. And then it turned out that all of the lawyers that thought that were apparently dead wrong. So on February 17th, 2022, the 10th Circuit Court of Appeals reversed that Colorado District Court's decision, granting a very broad injunction that covers all federal contractors, including probably everyone on this call. The court said, we enjoin the government from enforcing the minimum wage order in the context of contracts or contract-like instruments entered into with the federal government in connection with seasonal recreational services or seasonal recreational equipment rental for the general public on federal lands. A shorter way to say that would be we tell the federal government they cannot enforce these executive orders for federally permitted outfitters, period. This means legally that all of what is in that executive order is on hold. It's sitting in this legal purgatory where it cannot be enforced by the Department of Labor. It cannot be enforced by the Forest Service and your contracts. It's not presently enforceable. So everything we talked about previously with the executive order, what it means, what its provisions are, that for now is on hold. And we're in this place that I would fondly refer to as purgatory. And I'll explain what that means. Well, it sort of seems like, oh, this, high court issued an injunction on the executive orders, we're in the clear. That's not really the case. We're in the clear for a little bit on the executive orders, but that could change at any time. So it really just puts us into a place of uncertainty. So here's the present legal landscape. The executive order and the associated Department of Labor rules could be reinstated by the 10th Circuit Court of Appeals or the US Supreme Court at any time. So the 10th Circuit could change its mind. That's certainly possible, or it could get appealed to the US Supreme Court. No one knows when, whether, how this will occur, if at all, but that could happen. A second possibility is President Biden could try to get to the same place in a different way. So a way that does not implicate the same legal issues that were decided by the 10th Circuit Court. Could try to reinstate the rules in some other roundabout way. Third, and this is an important point, the current requirements of the Fair Labor Standards Act that have always applied still apply. And I'm going to tell you what those are, but that's important because of this fourth point. There's a significantly heightened risk of enforcement actions under the Fair Labor Standards Act, even if that EO is not officially reinstated. So that's a detailed explanation of why no one should be spiking the football on this issue. We're all still going to be dealing with these rules and having to plan carefully, even though it's not specific to the executive order rules. And this is a slide about the Fair Labor Standards Act. I'm going to assume for purposes of this presentation that there are some people who know about this, some people who don't. Varying levels of compliance in Idaho and across the nation. The Fair Labor Standards Act, as I said, has been the existing law for quite some time. It's required minimum wage at $7.25 an hour. Overtime pay has always been required after 40 hours. And there were some exemptions or exceptions to that. There has always been a possibility of a tip credit towards the wage requirement. And sleep time calculations, so whether guides are on duty on the clock or whether they're asleep, that has also always been relevant under the Fair Labor Standards Act. This law has been in place. It was in place during all of this EO discussion, and it remains in place. So the way to look at this whole legal landscape is this foundational law, the Fair Labor Standards Act, still in play. It laid the foundation for those executive orders, and that second two layers of the cake are what are uncertain, but that foundational layer is not.
Leah, can I interject real quick? So that $7.25 an hour, just to be clear, this is more mandated by the state that you're in. I don't know where all the outfitters on this meeting are. Is it per state?
So if state law requires, certain states have different minimum wages. So if, for example, you're in a state that requires $8.25, you pay the highest. Correct. So Fair Labor Standards requires $7.25. You pay higher if your state requires it. You pay the highest of the two. Idaho is the same, $7.25. So the analysis is the same. Good question, Ari, thanks. So this foundational law still exists, and because of all of this scrutiny on the outfitting industry under these EOs, the Department of Labor is paying a lot more attention than it ever has. That's why this still matters. Many of my clients are already in compliance with the Fair Labor Standards Act. Many people I talk to are already in compliance. It's a different set of math, but it's possible that if you're operating on the day rate program and you haven't done some math, that you're not in compliance, and it would be smart to pay attention to this sooner rather than later. Aaron, you want to jump in and I'll do the slides for you?
Absolutely. So I think this section dovetails right out of that. And for those who know me, I'll probably just say some of the same things Leah put pretty succinctly in more words here. Leah, if you wouldn't mind going to the next slide. So here are some reasons why we're still having this conversation. Well, why we are talking at you about these things and why we should continue to have this conversation, why it's still relevant. So as Leah mentioned, outfitters and guides specifically were targets and really the only named target in the executive order. So there's a screenshot, I think, up on the screen from the first page of the summary memo on the executive order. If you read through the rule, read through the executive order itself, it's just as plain. But we were the only named industry, which is pretty unique. And what that means, what that demonstrates, just to really drive it home, is that we would be foolish to not expect increased scrutiny. As Leah said earlier, when an administration identifies a certain industry group, whatever it may be, as a matter of policy, and when rules are then developed to regulate or to enforce whatever that policy agenda is, it is prudent to expect that there should be some oversight and enforcement, or at least an increased amount of oversight and enforcement. Again, in more words, just saying, we would be wise as an industry to expect increased scrutiny. Next slide. Let's see. Okay. This is just a little tidbit taken out from this happened on February 7th, fittingly, but just noting that the Department of Labor is hiring additional investigators in the wage and hour division specifically. If you Google it, there are more press releases, including a number on the Department of Labor site, all of which signal an increased focus on wage and hour enforcement. Next slide. So the first reason we're still talking about this is the increased scrutiny over our industry, the focus of the administration and the Department of Labor on our industry specifically. The second is more severe consequences, period, for non-compliance with the Fair Labor Standards Act and other related acts, so like OSHA, which is not strictly not the same thing. We all know what OSHA is, but the point is the consequences are much more severe than they were before. And we just have a couple snippets in here that speak to that. That's a pretty straightforward one. Next slide. The third reason is, and this isn't a negative thing, but the third is that we are in a much more connected and informed, at least in a certain sense, environment these days. And this issue has gained a lot of press. Unfortunately, a lot of that press is really misconstrued where it came from and what the actual state of things is. So here's a screenshot, and I don't bring this up. I'm a member of this group just to look at it, but this is an example of some of the conversations that are happening online in the guiding community. And I think it's coming from a good place. It's coming from folks in the industry who think that and in different places largely than Idaho, but who think they deserve better pay and who are looking to have their rights as employees recognized in a more significant way than they have maybe previously been. I think this is just an example, one, of why we don't have the luxury of having this conversation or not having this conversation. This conversation is happening. We get to choose whether or not we participate in the conversation, and we'd be foolish to not do that because there's a side of it that is not being talked about. Very few people really have the insight into what actually goes on with the actual consequences of EO 14026 or other similar such regulations would be on the industry. So the industry at the very least needs to talk with itself about it. Next slide. So the next one here. This just brings it all home. It goes back to what I think Leah maybe ended with, which is that this EO was released and the final rule in particular was released. And the final rule drove home just how serious this was. And I think everybody in the industry had a real come to Jesus moment saying, this is big, this is scary, this is hard to adapt to. And then with news of the injunction, I think the understandable knee-jerk reaction was to say, like a deep sigh of relief and say, okay, we're good now. And I don't want to dampen the mood, but I'd say I don't think that's a very informed way of thinking about things, for a number of reasons, which Leah I think touched on. But one, the injunction could be rescinded at any point. Two, the president has fully within his authority to issue an executive order by a different number with the exact same words in it. That's something you could do tomorrow. The president also has in his authority to, through, for example, the U.S. Forest Service Organics Act, to tell the Forest Service, or separately the BLM, any federal agency, you are now going to require that your permittees pay their employees a minimum of $15 per hour. That could happen tomorrow as well. So even short of the requirements that we have been and remain subject to through the Fair Labor Standards Act and other acts governing employee-employer relationships, the reality is that this EO, whether in name or effect, could be back on our doorstep tomorrow. And I think the worst case scenario for an operator would be, I go forward thinking this isn't happening, and I stop planning for it. And then midway through my season, this or something similar comes back and I'm completely unprepared. So as outfitters, and guides, we know that the only thing we can do is try to control to the degree we can the things we can control to any degree. And this is a great example of that. We can't control much of this. What we can control are the degrees to which we prepare for different contingencies. And that, I think, is sort of the cherry on top, or the culmination of why this conversation is still highly relevant. Next slide, Leah. I think that might be, nope, there's another one. Number 5. So number 5, I think I somewhat just spoke to, which is whether or not EO 14026 or any other executive order, any other executive action or set of requirements similar to it do come back or are implemented, we remain subject to the same foundational requirements through the FLSA as we previously have been subject to. And while I think that many outfitters in Idaho have been practicing compliance, there are certain areas that are, I think, just naturally not a very good fit for outfitters or for guides, including but not limited to more granular tracking, recording, reporting of hours worked. So for example, do I have to sign off on how many hours I slept? Do I have to sign off on the 20 minutes that I went off on a hike by myself at camp? Or do I have to have that programmed in order to be allowed it? What is compensable time, in short? And what is overtime, or when does it start? We actually know those answers, but reporting on overtime, the record keeping associated with it, especially when you have employees that are going from river trips to shop work to shuttles to different types of things. Tip reporting for guides. All of these other things are the basis of the conversation we were having anyway. And I think it just brought it to the fore. So given the increased scrutiny, again, I think it just underscores how important it is that we all take those things into account and make sure that our house is in order. And I think is that the end of my initial section here, Leah?
Nope, you're still going.
Oh, I'm still going. you guys, I'm still going, so you're welcome. The next section, that is my section, is so how outfitters can help IOGA themselves or employees regarding the executive order, which we just discussed, whether or not it comes back, or another one is issued, wage and hour, OT issues, on and on. The first thing, and I think the most important thing, next slide, Lee, if you would, is that, and this goes both ways. We're gonna have a guide presentation, and I'll say the same thing in reverse, but communicate with your guides and employees. So again, times have changed. Folks are aware. Guides know that this is a thing. I promise you they do. I get enough calls. Guides know this is a thing. They're interested, they're engaged, they want to understand. And they're not, and I'm sure outfitters know better than anyone, they're not just out for themselves. They're genuinely interested and concerned also for their employers. So talk to your guides, talk to your employees, answer their questions to the degree you can, tell them if you can't, and reach out for more help. But just at the very least, have a conversation about what you're doing. Try to figure out where they're coming from. Make sure that you're on the same page. Review your own practices. If you're unsure whether or not you are in compliance in any given front, or that you are ready to be in compliance should the executive order or something similar come back into play. It's deeply complicated stuff. So I'd recommend contacting a Leah or somebody similar who actually knows what they're talking about. That's what I do. Read your email. I'll leave that there. Just read your email. We're sending out information pretty regularly, and usually try to vet it quite a bit before we do send it out. So Google's changed its algorithm. If you're not getting IOGA emails, you almost certainly should be. So go to your promotions folder, make sure we're a trusted sender. Follow through on the calls to action if you believe in their outcome in those emails. So oftentimes we'll have a link to Congress or contact your congressionals about something. We've been talking to our congressional delegation, both in conjunction with America Outdoors, as well as independently on this and other issues. But they just need to hear from you one way or another on this issue. And there is pending legislation that would provide a partial exemption from the overtime and overtime reporting requirements for the industry that we've been talking to folks about. So we can give more information to you on that later. Finally, I'll just do the quick plug. If you see fit, you can consider donating to the overtime war chest. I'm sure that we can get a link into the chat here at some point. Basically, that's a fund that's been put toward just responding to and this issue in general. So from education to contracting legal counsel to the opportunity fund for any legal action we may, as an association, choose to take going forward. The creation of the tool, which is so close, it's in final review with a wage and hour specialist. That will remain super relevant for folks to make sure that you are in compliance, and lest any sort of executive order similar such requirements come back into play. And with that, we are out of my section. And into, unless Leah, is there something you wanted to add to in that section at all before going into any questions folks might have?
Yes. Couple of things. First of all, I think it's really key, just like what you all do in the outdoors. This is not a freak out thing where you either, run at it full on like a brick wall or bury your head in the sand. It's a discerning, measured approach to attacking this problem is important. I do think that by the numbers, probably not by record keeping requirements, but by the numbers, a lot of you under the FLSA requirements are probably okay or close. So that's going to be super individual situation. But what I would encourage you to do is understand that foundational issue of the Fair Labor Standards Act. Get your house in order with that. And then if these EOs come back into place or something similar comes back into place, you'll already have that foundational framework to plug the new rules into. So if you look at this FLSA stuff, make some decisions around that, the numbers will be adjusted, certain things will change, but that basic foundation will be there for you going forward. And I think that will take this big uncertainty and make it more of a problem that's waiting out there, but it's not an overwhelming dark cloud of a problem. It's something that you can handle.
Leah, can you clarify something? I've got a question right now. So the difference, so based on the FLSA number of $7.25 an hour, or so this temporary stay has released the Biden executive order, but how are we not going back to the Obama order of the 11.25 non-tipped? How'd that happen?
So the concept there is that if Biden didn't have the executive authority to put in place his executive order, then no president does. So I think while that injunction specified the Biden order, it's handwriting on the wall for the enforceability of executive orders of that flavor. Aaron, do you have any additional comments on that?
I do. I'll just give the caveat that folks know, but I'm not a lawyer. I'm definitely not a lawyer. So anything I tell you is at best logic and more likely secondhand. In this case, what I'm about to is secondhand, not from Leah, but another lawyer. One way it's been framed to me is that the injunction bars implementation or halts implementation for those identified groups. So outfitters just without getting into the terminology, outfitters guides, let's say, recreational special use permittees. That blocks the executive order. That doesn't actually block the regulation. And Trump, since the Biden executive order superseded the Obama executive order and rescinded the Trump executive order, because the implementation of the Biden executive order has been halted, is actually no longer rescinded for the group of people that the injunction applies to, which is us. And namely because the Trump executive order was executed through regulation. So it wasn't just the policy statement, like it is the policy of the United States that outfitters guides are exempt, which I actually saw a question in the chat about that we can get to in a minute. But in regulation, the Trump executive order put through the exemption that for our industry in regulation. So the Obama executive order remains superseded by the Biden executive order, but the Trump executive order is still in regulation. And you can't repeal regulation. Or supersede regulation. So to your question, Ari, to the extent I understand it, one, I think I put in the newsletter, if anything, this has made it a little bit grayer in terms of where specifically we are. I still think that's true, because I think, and Leah would be a better source, but I think that we may be subject now to the Trump executive order through regs, but I don't know that Leah, I don't know, would we know until there was actually a case tried?
Right. No, any answer that anyone gives you on this is purely speculative. But the idea, again, is if you remember from the last Campfire talk, Obama entered his order. Trump's order came after that on top of it, and it changed it re-exempted everyone. So my interpretation is that's still in place because Biden's order tried to resurrect part of Obama's order, and that has been successfully challenged. So it's a little bit gray. My interpretation, for what it's worth, in this educational presentation is that the Obama and Biden executive orders do not have the force of law for recreational establishments right now.
So just be clear, the FLSA still there, still a thing, doesn't go away.
Right. Yep. So, final point is communication is key. Calm, discerning planning is key. We're out from under the executive order increases for the moment, but that could come back at any time. So everyone needs to pay attention. Focus your attention right now on FLSA compliance. If you haven't done that already, that'll give you the foundation for getting your house in order, and it will make everything that comes next easier.
Yeah. We do have a couple more questions in the chat, Lee. If we have a couple more, I think we do have a couple more minutes if you're up for it.
Sure.
So, and I'm happy to take a stab, but I'll give you first shot on them. So Matt Canoy asks, and both of these are on point. We were just talking about, was the outfitting industry specifically identified when President Trump changed/adjusted the President Obama era EO?
Go ahead, Aaron. You have that one down, Pat.
Yeah, the answer is yeah. I mean, pretty short answer, but yes, and pretty explicitly. And that's part of my frustration without, and I don't say this in a partisan way. We're just caught in the middle as an industry. I think pretty clearly. So it's pretty clear that it's not pretty clear. It is the case that Trump specifically targeted outfitting and guiding as an exemption. And it is also absolutely the case that the Biden EO and rule definitely target outfitting and guiding in a much more explicit way even. So whereas on the Trump EOs, like recreational multi-day service providers who are or not oftentimes in wilderness, something like that, for Biden, it's outfitters and guides. And then it's very specifically into permit types and then changing what contract means. So yes, Matt, to your question. The other question is Steve Zettel asks, I thought the EO 13658, the Obama executive order, minimum wage had increased to $11.25 on 1/30/22. I believe the non-tipped minimum is $11.25, right, Leah?
Right.
Maybe I may have put some other information in there, Steve, or said something else. Let me know if there's more clarification on that question. And then while we're in here, we'll have the guide session here, guide campfire here coming up in a little while, but here's another question. So under the FLSA, outfitters are still responsible for overtime pay. Leah, you want to take a stab first?
Yes. Yep.
Oh, wow. Okay. There's a long one.
There's a long one in the chat, so we'll read that.
While Leah is starting to read that, I guess, Phil, short answer is yes, all of the tenets of the FLSA. And I think one of the takeaways, Leah spoke to it here just a minute ago, but one of the takeaways, hopefully from this, at this juncture in the conversation, we'll keep on having the conversation either via newsletter or things like this. But one of the big takeaways is, I'm with Leah. I think our industry has done a good job trying to be in compliance with the important parts of the FLSA. I think we just really need to make sure that we are, that each outfitter goes back and makes sure that their house is fully in order on that front, because the likelihood that there could be investigations, complaints, investigations, et cetera, is just significantly higher than it was before this last executive order. That doesn't mean it will happen. Probability is a really big place, but improbable things happen all the time, and we've just increased the probability. So in the time I was talking, Leah, did you get the gist on Jonah's question?
Yes. So Jonah, that the exemption from the FLSA could apply to certain people in this group, but what I want to convey base level is that for a lot of you, I don't think it does apply. And that's a super case by case scenario. So Jonah put the citation up there. You can review that and see if you think you're exempt under the FLSA. Many Idaho outfitters are not going to be exempt from overtime requirements under the FLSA. It's case by case basis, but Jonah, that's an excellent point.
we actually, and Leah and I actually talked about having a whole section on possible exemptions in here, and there are a lot of possible ones. Unfortunately, and Leah may have a different perspective, my read, having spent a lot of time with them, is very, 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 very few outfitters in Idaho would even maybe be eligible for any of them. If you think you are, definitely worth following up, like just in general. But whether to the seasonal amusement recreational establishment or any of the others, interstate commerce stuff, the $500,000 criterion, blah, 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 it's extremely unlikely, speaking from the top level.
Yep, I agree. Lance, your question, just so I understand the nuts and bolts of minimum wages and overtime, what would the minimum wage per day for a first year river swamper be? It's a good question. And I can't do math without a calculator and really focusing. But an important point in your question is, it doesn't matter how much experience the person has. So the minimum wage and overtime requirements apply uniformly to all workers. So you need to think about, if you're paying more experienced people more, you're paying above that foundational level. If somebody else who can do math on the fly wants to take a stab at the rest of that, that's great. And then Colin, your question about record keeping requirements under the FLSA. This could be kind of a complicated answer, because again, it depends on your operation and the choices that you make. But I would say, to the extent that you're using tip credits and break credits and keeping track of sleep and breaks and et cetera, it's probably not incredibly different in terms of record keeping requirements. If you weren't using tip credits and you would just decided to pay everyone minimum wage plus overtime, then I think it's fairly straightforward and wouldn't require hiring a new position. Aaron, do you have any disagreement with that?
No, I would just, to Lance, your question, I would just add, so one is 116 would be assuming 16 hours, which actually gets to a question that I think what Willie has down below. But there are, so in the FLSA, like I said, there are a lot of exemptions, a couple of them that are something that an outfitter could look at for, say, first year swampers. Somebody's just sort of coming along to see if it's a thing they might want to train into. There are exemptions for folks that are younger than 20 for, it's like employed minor. I can't remember the actual name of the exemption, but it's, 3 months consecutive after the date of hire that they can be paid a lower wage than the federal minimum. Idaho also comports with that. There's like an apprenticeship that is more record keeping. Depends on how willing you are to get that granular. And I would agree, Colin, to your question. That's a really good question. But to your question, I would agree with Leah, the fundamental requirements are the same. So, and that's one of the reasons that I just come back to this conversation, even beyond the fact that, again, the EO or something like it could be back any day or not, but it could be. And it wouldn't be unreasonable to expect it. But beyond that, all of those record keeping requirements are from the FLSA. That's what Leah was talking about with the foundation that we're all still subject to. So something to double down on. Willie, to your question, that's probably more of a Leah question, I think. Leah, do you have any take on that? He asked, or did you see it there?
Yeah. So I think that would be really smart just from a industry perspective. So guides aren't, shopping around for different hour standards with different outfitters. You can, under the FLSA, if I'm recalling correctly off the top of my head, you can agree with your employees in writing about what their sleep schedule is. And if everyone in the industry had that same standard, that certainly makes it easier to navigate this with guides. If everyone's doing the same thing, then it's not going to seem that strange. So I think that would be totally appropriate to the extent people wanted to participate in that.
And especially Willie, if I think that's maybe especially an opportunity if you're looking at a certain set group like Middle Park Outfitters, which you're a part of. And if everybody were willing to get on board, I know in other areas, folks aren't too comfortable with establishing a standard, because then if you're outside that standard, then, you're the odd duck out, but yeah. Jonah, see, I don't think that's a question.
Jonah's doing math. Thank you, Jonah.
Yep. Showing his work.
One other point, as anyone's thinking of final questions here, if you zoom way out at what's been going on with this wage and hour and overtime stuff for the last, 5+ years, America Outdoors, other organizations have been trying to get an exemption to the overtime rules under even the FLSA before these executive orders ever came out, that reflects the reality on the ground for seasonal recreational establishments, basically outfitted services. If that exemption was secured, that would really remove a lot of what we're talking about here. In my personal opinion, and this is just me looking at this from, as a guide would and from the outfitter side, that exemption would be very welcome. From the guide side, it would be welcome because I can keep being paid a daily rate. If that rate is too low industry-wide, then guides, it's a market, it's a labor market. If guides want to be paid more and you can't find qualified guides, you're going to pay what they're worth. And it allows you to have that negotiation in a framework that everybody understands. Also, you wouldn't be getting into the tip credit stuff. It would be a recognition of the reality that the overtime rules do not fit very well for what guides and outfitters are doing. Nobody's punching a clock. No one I know wants to keep a log on their boat or in their pack of logging every 15-minute break for a bath or a hike, logging their sleep hours, reporting exactly, everything they're doing in order to dovetail with these record keeping requirements. In my view, that's unwelcome for everybody. It's unwelcome for outfitters and for guides. So to the extent that an exemption can be secured by lobbying, I think that would be really valuable. And that's one of the reasons to stay engaged here.
Absolutely. Yeah. And it's, we'll be talking about this in just a little while in the guide one, I think at some point too, but it's really easy in this conversation for it to come across when and I'm a guide. I've been a guide for 16 years, but it's really easy for it to come across as, the industry just wants to take away overtime, whatever else. I really don't think that's the case. I know that folks that I work for pay better than what the math Jonah just did. And that if they, that if the market pushed it, they would pay more. And if the demand on the customer side allowed, they would do more. The other thing I think about is that if we were to have EO 14026 or something like it, or even if it were just otherwise required for an outfitter to be able to break, for example, to have employee schedules where beyond sleep time, you get to the beach and on day 3, you're not supposed to work, period. You're supposed to be off. And by supposed to be, it means like you are off. You're not allowed to work. I would have a really tough time watching my crewmates work and not go down and hang out in the kitchen and help or do whatever it is. I think it would take away, there are a lot of things in the lifestyle that I think this could take away. And an exemption from it, I think, would allow us to keep paying the same and or more depending on what the value and market demanded, while also having more of the flexibility that I think most of us appreciate for it, or in the industry.
Yeah.
Any final, Ari, Leah, any final thoughts before we close this one up and take a pause before the guide session?
Not for me.
Nothing coming to my mind.
Well, then I'll just say I really, really appreciate folks showing up. I didn't get a chance to really look through the participant list and see who all is here. But we will be having the guide campfire here in starting up at 30 minutes or so.